All right, let's talk about the Queensland Evidence Act. If you're gearing up for the bar exams, you know this is a big one. Mastering the act isn't just about passing, it's about winning. Today, we're going to dive into some really key provisions that can absolutely make or break your case. Let's get right into it.
So, picture this. You're on your feet in court. Your entire case hangs on a statement from one key witness. But they can't be called to the stand. Maybe they're overseas, maybe they're too ill. This isn't just some tricky exam question, you know. This is a real-world problem you will face as a barrister. So what on earth do you do now?
Okay, here's how we're going to break it all down. First, we'll look at the challenge itself. Then, the Section 92 gateway, your way in. After that, the big one, the difference between admissible and persuasive evidence. We'll also cover a couple of other handy procedural tools and then wrap it all up with the key takeaways for the bar.
So let's start with the challenge. And look, we're not talking about some abstract legal theory here. These sections of the Act are your practical toolkit for solving a very real problem, one that you'll probably run into a lot sooner than you think. Here's the pickle you're in. You've got this signed statement, and it's gold. It's got the information you need. But the rule against hearsay is staring you down. Normally, you can't just hand up a piece of paper. The person who wrote it needs to be in the witness box, ready for cross-examination. So how do you get this document into evidence?
So what's the answer? Well, thankfully, the Evidence Act gives us a direct path around this roadblock. Your first port of call, the key you absolutely need to have in your pocket, is Section 92.
Think of Section 92 as your legal gateway. It's designed to help you, not to trip you up. As long as you can meet its conditions, proving the witness is unavailable for a good reason, like they're overseas or it's just not practical to call them, it lets you get that statement in, completely sidestepping the hearsay rule. It opens the door for you. But, and this is a huge but, just getting through that door is not enough, not even close.
Okay, what we're about to cover now is, I think, the most critical lesson for any aspiring barrister. It's the huge difference between what the law says you can do and what actually works in front of a judge. This is where the real art of advocacy kicks in. And here you see that fundamental tension in action. Section 92 gets your statement admitted. That's the technical black-letter law step. But then Section 102 comes into play, and that's where the judge gets to decide the weight, or, let's be blunt, the actual value of that statement. So what's going through the judge's mind when they're weighing your statement under Section 102? Well, they're looking at things like, was it made right after the event happened, when it was fresh in the person's mind? Did the person have any reason to, bend the truth? And crucially, the judge is always going to be thinking about the fact that this evidence can't be tested under cross-examination. These are the real hurdles you've got to clear. The theory is one thing, right? But the cut and thrust of the courtroom, that's a whole other ballgame. So let's look at a perfect and honestly a pretty sharp-edged example of how a judge can use this power. This is just brilliant. It's an old story, but it's gold. A barrister gets a statement admitted under Section 92, feeling pretty good about it. And the judge, Bullingham J., just looks at them and says, well, it may be admissible, but it has no value. You had better tender a paperweight as well. Ouch. It's a brutal put-down, but it perfectly shows you the power a judge has to just dismiss your evidence. So here's the lesson. Your job is not done once you've ticked the boxes for Section 92. You have to be ready to stand up and argue why that statement is not just admissible, but why it's reliable, why it's credible, and why it's persuasive. You've got to convince the judge that it's a lot more than just a paperweight. Okay, mastering hearsay is one thing, but a great advocate is also an efficient one. You need to respect the court's time. The Act actually gives you other tools to help manage evidence and streamline the whole process. Let's take a quick look at two of them, Sections 129A and 129B. Think of Section 129A as your efficiency hack, especially in civil cases. If proving some minor fact through the whole formal process is going to cause a ton of unnecessary expense or delay, this section gives the court the power to say, let's find a simpler way to do this. And this table here breaks it down really nicely. For things like proving handwriting or for facts that nobody's really arguing about, the court can just order that you prove it with a simple statement or by handing up some copies. It's all about being practical and keeping the trial focused on what really matters. Now, Section 129B is another powerful little tool. It basically confirms the court's power to look at someone sitting in the public gallery and say, you, right there, you're giving evidence now. It lets a judge compel someone who's already in the room to get in the box, even if they haven't been subpoenaed. Definitely a useful one to have in your back pocket. Okay, let's pull all of this together now. We've gone through the hearsay gateway, the absolutely critical role of the judge's discretion, and a couple of great efficiency tools. So what are the main strategic points you need to be taking away from this for your exams and, more importantly, for your career at the bar? First, and I can't say this enough, Section 92 is just the gateway. It's not your destination. Second, you have to be proactive. Make arguments about those Section 102 factors. Tell the judge why the statement is reliable. Third, never ever forget the paperweight. Judicial discretion is very real and very powerful. And finally, use tools like Sections 129A and 129B. Show the court you're an efficient advocate who values its time. And that really brings us to the final question, doesn't it? The one that defines your career. It's one thing to know the rules, the sections, the cases. It's something else entirely to stand up in court and use them to actually persuade someone. The best advocates know their job isn't just to state the law, it's to practice the art of persuasion. Definitely something to keep in mind as you prepare for the bar.